Buckle up, courtroom fanatics. This case is a whirlwind. Today, we're diving into the sentencing of Marlon Daniels, a military veteran turned defendant, standing before the court in two separate felony cases. 2024, CR 0009218 and 2024, CR 0009219. With 18 years on the line and a plea deal on the table, this hearing is full of emotion, heavy decisions, and some shocking revelations. Why did Daniels plead guilty when a jury might have given him less? What did the judge uncover in his pre-sentence investigation? And what did his military background have to do with it? Stick around because this isn't just a sentence. It's a story of accountability, remorse, and the hard truth about justice. Let's break it down.
009-218 and 2024 009-219. State versus Marlon Daniels. Can I have parties announced for the record?
Megan Galloway for the state.
And for the defense?
George Sharman on behalf of the defendant in these cases.
All right, and you're Mr. Daniels?
Yes, ma'am.
All right. Mr. Daniels, the court, at the request of your attorney, had a PSI ordered. And Mr. Daniels, we're going to proceed with sentencing. And each of the cause numbers, you entered a plea of guilty, and the punishment is to be assessed at 18 years in the prison.
This is a powerful moment. The judge brings up Daniels' military service, a clear effort to show the court recognizes not just the crime, but the man behind it. But here's the twist. While the judge commends Daniels for his service and owning up to his mistake, she also doesn't budge on the consequences. This is where the law and humanity collide. It's not just about whether someone regrets their actions, it's about accountability and the impact of those actions. The judge even notes that no one sets out to drive drunk, but the results are often tragic. Question for you viewers. If a defendant has served their country and takes full responsibility, should that lower their sentence, or should justice remain blind to personal history? Let us know in the comments.
Mr. Daniels, I've had a chance to learn more about your background from your attorney, your military service. And I will tell you, I know that no one, at least I have yet to have someone come before me and say my intention was to get drunk and go out and hit somebody, or get drunk and drive drunk. Nobody ever intends to drive intoxicated or get to that point, but it happens. And that's why I always try to stress to everybody, please, please, if you're going to be drinking at all, even if you think it's just going to be one drink, it's better just to have a designated driver, right? Okay. And I do appreciate the fact that you entered a plea, that you accepted responsibility by pleading guilty, and that you have not wavered and try to blame something else for this. I do note that you said that you couldn't remember, but you know it's true, and I appreciate that. Sometimes people will say, well, I don't remember what happened, so I'm really not responsible. But you didn't do that. And the fact that you entered a plea, and in each of these cause numbers, you were looking at 20 years. And I always tell people, when people go to jury trial, even when I was a defense attorney or as a prosecutor, I sometimes would have to explain to families, you don't know what 12 people are going to do. Right? When you go to jury trial, you don't know. 12 people could say, you know what? This person before me is a military veteran. This person before me hasn't been in trouble. Yes, they did this, but we're not going to give them 18 years. Who knows? A jury may decide to have given you 2 years or 3 or 4 or whatever. You just never know. So for you to accept responsibility, for you to take the 18 years, knowing that by taking these 18 years, there is no appeal because you waive your right to appeal. I think that says a lot, even though I know that the family is in a lot of pain, because when you lose someone and you lose someone this way, it's not expected. So the court is recognizing that you entered pleas of guilty to each cause number, that you accepted responsibility, and you took close to the maximum sentence in each of the cause numbers. With that being said, And cause number 2024 CR 009218. The court will follow your plea bargain agreement as previously stated. When you entered your plea, the court is finding you guilty. The court will sentence you to 18 years in the prison. There's a $2,000 fine. The court will give you credit for any time served, and legally, you're entitled to any time that you have served on this case. This will run concurrent with 2024 CR 009219. I'll request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. It's merely designed to help you maintain your sobriety, address any type of mental health or substance abuse issues you may have so that.
Now this part is layered. Despite the 18-year sentence, the court is still pushing for something called a therapeutic community within the prison system. That's not a free pass. It's a targeted rehab program aimed at treating addiction and mental health. Translation: the court isn't just punishing, it's also trying to rehabilitate. But don't overlook the gravity here. The judge also enters an affirmative finding of a deadly weapon. That's a legal designation that can significantly affect parole eligibility and shows the court sees this as a serious, dangerous offense. Here's a legal tip. When a deadly weapon finding is attached to a sentence, it's not about whether a gun or knife was used. Even a car in a DWI case can count if it resulted in death or serious injury. And that can add years before parole even becomes an option.
Ultimately, when you're released from prison, you will maintain your sobriety. And there's an affirmative finding of a deadly weapon.
May I address the court on the matter?
Just one moment.
Yes.
And cause number 2024 CR 009219. The court is finding you guilty. The court will sentence you to 18 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. This will run concurrent with 2024 CR 009218. There is to be restitution of $60 to DPS for testing. And the court will recommend the therapeutic community. There's something you wish to say, counsel?
Yes, on the PSI, it said that he had the combat risen. He did not have combat written. So that was erroneous.
Okay.
Step number 2, it shows there were 2 priors of misdemeanors. There was only 1. And if you look at it, it's the same date on each.
Okay. All right. Is there anything else?
That's all we have.
All right, Mr. Daniels. Deputy Laura, if you'll give him his trial court certification.
Correct.
All right. Counsel? Counsel.
Yes.
All right, your client has been removed from the courtroom. Did you review the trial court certification of defendant's rights to appeal with him?
I did.
All right. On the record, the court informed the defendant that by entering the plea, he had waived his right to appeal, so he acknowledged that. I followed the plea bargain agreement. So because I followed his plea bargain agreement and because he's waived his right to appeal, he do not have the court's permission to appeal.
I went over that with him, Judge, so he understands.
All right, thank you.
And there you have it. Marlon Daniels, convicted in 2 serious cases, sentenced to 18 years, with both terms running concurrently. His military service was acknowledged, but the weight of his actions couldn't be ignored. A deadly weapon, finding and restitution to the Department of Public Safety sealed the deal, while the court hopes rehabilitation through the therapeutic community will guide his future. This case underscores a powerful truth. Accepting guilt doesn't always reduce the penalty, but it can preserve dignity and show respect for the process. Daniels made his choice. The court made its call. If you found this case as shocking as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. This is real justice, raw and unfiltered.